welcome. Nice to have you here. I hope you all had a nice 4th of July holiday. We will begin with our usual housekeeping instructions. Please know that we are not here to give legal advice. This is just general legal information. The chat function is intended for questions or requests for clarification, and commentary in the chat is not to be considered legal advice. You may wish to review our recent Q&A videos for primers on upcoming legislative changes. We've had a lot of questions about that, and we do have a good deal of information in our Q&A archives on these particular changes. For example, we recently did one on executive session, so if you have questions about that, you can find that information there. You may email us at info@condolaw.net with any suggested topics for primers that are of interest to you. Be aware that CA Day this year is October 18th, 2025, and we wanted to also just remind everyone that I know there's been a lot of information going around about the legislative changes. The changes to WUCIOA do take effect on July 27th, and several provisions from WUCIOA will become binding on all communities, but not until January 1 of 2026. These are relating to the meetings and collections notices. We would like to let you all know that we are going to be canceling the August 6th Q&A session. We will be moving offices effective August 4th, and that week we will be working on getting ourselves set up there. We have 9 questions today, so please, if you have any questions that you'd like to add now, go ahead and add them to the chat, and we will get to them after we've completed answering the questions that have already been submitted. Okay, I think we're going to move forward with the first question. Ken, do you want to take it from here?
Sure. First question is, if a board reaches out to a law firm for an opinion letter regarding an architectural review change, would there be any reason why that document would not be an open record of the association? So the short answer is that every legal opinion is a privileged communication, and that privilege belongs to the board of directors. Attorneys give their advice to and take direction from the boards. And so the records section of all of the statutes provide that privileged communications can be withheld from owners. And that would include all owners, even the one who's made the request. So the association, it would not be a, quote, open record available to any owner. And part of the reason may be that a legal opinion could include a range of options which a board might make regarding a particular question, whether it's an ACC request or review of a contract or something else. And what the board finally decides is what gets communicated to the owner or the third party, not the whole range of options which might be available. The attorney cannot substitute their own opinion or judgment for that of the board if the decision is within the discretion of the board. So anything you want to add, Tima?
Nope, I think that covers it. The next question, quick, short question, short answer. I just listened to Valerie's wonderful primer on Senate Bill 5686. If expansion of the foreclosure mediation program takes effect this month for HOA communities, would you please tell us where in this confusing bill it says that? It doesn't say that, so that's why you can't find it. The foreclosure mediation program does not take effect until January 1, 2026 for non-WUCIOA communities. We agree it's confusing, and in fact, we may have given incorrect information at one of our prior Q&A sessions, but this is, as of now, that is the actual effective date, January 1, 2026. We still have a few months to get prepared on that. Number 3, Ken, unless you wanted to add to that.
No, nothing
okay,
to add.
I think that's all that's the answer.
I think we're still going to have a lot of confusion about which statute applies until January of 2028, when hopefully there will finally be a single statute for everybody. But then the problem will be that it conflicts with the written governing documents for so many communities that people will be then arguing that their document says something different than the statute. So
Yes.
life is just not going to become easy. Next question. The management company we use charges a transfer fee when there's a new owner. What needs to be in the declaration for the association to allow such a fee to be charged to the new owner, or is this a fee that should be absorbed as a common cost? We are under RCW 6490. So it's not going to matter which statute you're under. I'll start with saying we can't offer legal advice on this, in part because we do not have the specific governing documents or the management contract, which might establish whether or not there's an obligation between the association and the management company for a transfer fee. Okay. So the question really becomes one of whether or not the manager can charge a fee to a new owner, which is outside of the declaration or CC&Rs. It has certainly become common practice for management companies to charge fees, and it is not a fee that the association would ever pay because it is not within the contract for the management of the association in most cases. But again, we don't know what your contract says. It is certainly possible that the governing documents include a transfer fee payable to the association. And it is also possible that in addition to that transfer fee, the management company is still charging a transfer fee to the new owner. And the theory is that the management company is providing a service to the owner. And if they are providing a service to the owner, they are allowed to charge a fee for it. The primary legal authority comes from an appellate court case out of California some years ago, where an owner had sued claiming that the management company could not charge any fees to owners. And the court came back and said, well, there's no reason the management company can't operate a business for profit. And if they are providing services to the owners, they can bill the owners. And so I would say in most cases, we would not expect transfer fees to be an association obligation unless it is in the contract between the manager and the association. And so there wouldn't be a reason for the association to absorb that cost. Anything you want to add, Tima? You're on mute.
Sorry, everyone. All I was going to say is that when we on the collection side, are providing a payoff and there's a transfer fee that is associated with the payoff, we very clearly have that as a separate charge in the owner ledger, not as part of the collection amount. So, that is something that we will collect upon on behalf of the association and the management company if it's authorized in their agreement, but it's not something that we are directly collecting from the owner. Okay, question 4. If a unit has a garage and a driveway, which is considered a limited common element, would it be a reasonable restriction to limit installation of charging units to the garage only and not make outside the garage in the driveway an option? Thanks. We are looking at needing to make a quote unquote reasonable rule. Well, I think the short answer to this question is yes, reasonable is important here, and whether or not it is reasonable is going to vary from community to community. So, because it's going to be very specific as to the dimensions and the location of these chargers. That being said, so yes, maybe that it would be considered reasonable in your community. I can't speak specifically to that. Regardless, we would strongly recommend that you contact your association attorney to draft an EV charging policy. And that would specifically allow for the association to exercise reasonable discretion. So we have a model EV charging policy, and in our model policy that we provide to our clients, We suggest that the proposed location should be within the boundaries of the allocated limited common element, and it must not interfere with adjacent spaces. For example, there can be exceptions, and the requirements for installation may vary depending on the type of unit, and the association would approve or deny request, exercising, again, reasonable discretion. I would note that here, just based on what you're describing, if you were to limit EV chargers to only being inside garages, you would definitely want to articulate a reason for that, because having one outside of the garage, in certain situations and depending on the location, might be considered reasonable. So again, it's going to depend on your particular association. We do recommend having an EV charging policy if you're going to be getting into these types of decision-making situations. Ken, did you want to add anything to that?
Well, I was just taking a look. The EV charger section of WUCIOA takes effect for all communities of all natures effective January 1 of 2026. And so I was looking to see if it makes a distinction between a unit and a limited common element. And I don't see it right off the bat, and I don't want to spend time during this searching for it. But if you want to look at section 649513 of the Revised Code of Washington, that is the recently edited version of the electric vehicle charging station statute. And I think that, as sort of Tina said, we'd want you to be able to articulate a reason why it would not be allowed on the outside parking space before you adopted a rule. And there may be reasons. We just don't want something to be considered arbitrary because no one can articulate a reason.
Exactly.
Next question. Does the board have to provide the copy of vendors paid when they share the monthly financials? So I'm assuming this is when they say copies of the vendors paid, that they're meaning you have to provide copies of all the invoices or a list of every vendor paid. Well, the short answer is you don't have to provide them unless they're requested by an owner. These would be documents of the association. There would be no reason that the association could withhold them that I can think of. So if an owner requests the records, they're provided. There's another section of the statute which specifically says that any records which are reviewed by the board at a board meeting must be made available to owners if they request it. So if you're sending out monthly financials to owners and to the board, because people are trying to be well informed, you do not have to send copies of the invoices along with it. You don't have to send 70 pages every month. But if an owner were to ask for a copy of the invoices, you would be required to provide it under the statutes. Anything you want to add to that, Tina?
Don't think so. Next question is, when does the board raise the question on whether the board member is still active if the last two meetings they were not present? Is this in the CCRs or the bylaws? So the short answer to this question is every association's governing documents regarding their board members' responsibilities are going to be different. So without seeing your specific governing documents, I can only answer this question generally as to what is considered an active quote unquote board member. Also, generally speaking, most organizational documents are silent on this subject. So an absent board member is still a board member unless they've been removed by the members of the community through that removal process. Again, the governing documents might specify certain responsibilities either in the bylaws or the declaration or elsewhere in their governing documents. But when we draft bylaws, we include provisions that automatically remove board members who miss 3 consecutive board meetings. Some bylaws have other automatic removal provisions. So generally speaking, you'd want to have that in your bylaws if you don't. The statute also allows for delinquent board members to be removed from the board without a full membership vote. So, you know, there are ways to remove board members who are inactive, if the board, so, you know, if that seems to be necessary, or if that feels necessary. I mean, Ken and I were discussing the fact that, especially with remote Zoom and other meeting options, it's not reasonable typically for a board member to miss a meeting. There are provisions for a vice president to step in when a president misses a meeting or can't be there, but generally speaking, it is reasonable to expect board members to attend meetings, and removing board members through specific instructions in the bylaws for failure to attend consecutive meetings is certainly something we would recommend. Ken, do you want to add to that?
Well, it's certainly possible that a person is holding a board seat and intentionally avoiding the meeting because they're trying to block the board from making decisions. And so there are reasons you'd want to be able to automatically remove them. We certainly have had a number of situations where board members get elected and then they just don't participate. And it makes it difficult for the community to get things done. So we are supportive of having automatic removal, and we actually model ours after the way that credit union boards are set up, where the statute for credit unions states that a board member has to be removed from the board if they miss 3 meetings during a 12-month period. And the reason is that if you're not attending meetings, you cannot be fulfilling your duty of care to serve as a board member. But the condominium statute doesn't have that built in, so we try and build it into the bylaws when we rewrite them for our community. So next question. Does current law require that the yearly budget for a condominium association be approved by the owners at the annual meeting? So the short answer is no, because approval is not required by the membership. Ratification is required by the membership, and it is a different process. The owners have to be given an opportunity to vote, and they have to be given an opportunity to reject the budget, but it requires a majority of all owners. It's not something that requires the affirmative approval of the owners. The second thing is that this process does not have to be done at the annual meeting. In fact, many communities have a separate budget ratification meeting that would be prior to the end of their fiscal year or calendar year, and that's usually separate from the annual meeting. Part of the reason it's become separate is that the budget ratification process started to exist for all communities in 2018 when WUCIOA was enacted, and the requirements for annual meetings usually put those in, you know, the first quarter of the year, and the timing just didn't work out well. So the requirement to ratify a budget became a second meeting each year for all owners. The second part of that question is it required that a budget estimate of the dollars to be added to the reserve fund be a part of the annual budget, especially if the association's reserves are significantly below the amount estimated in the reserve study? So the short answer is no, there is no statutory obligation to include any reserve contribution in the budget. If there is a planned reserve contribution, it should be a line item in the budget. And I will say that banks will frequently look to make sure that a minimum of 10% of the annual budget is submitted to reserves, because that's still the only standard the banking industry uses to decide whether or not an association is adequately funding reserves. So that affects your ability to get a mortgage. But there's no statutory requirement. The legislature has set up a system where owners have to be informed every year about the status of reserves, about what the consultant is recommending be set aside for reserves, what the board is actually setting aside for reserves in their budget, and making sure that owners are informed so that if the association is not saving enough money, individual owners can plan to cover that potential on their own. Anything you want to add?
Nope, I believe that covers it. The next question. Does state law stipulate what percentage of owners must participate in the annual meeting for the business conducted and the elections to be valid? Or is this strictly a matter to be found in the association governing documents? So first, I would say that, yeah, the specific percentage of ownership votes required to enforce a vote is identified in the governing documents for association sometimes, but not always. So in the absence of any specific reference in your association's governing documents, there is statutory authority under each of the statutes for specifically what is required. So I'll just briefly mention for WUCIOA under 649450 section 1, 20% is the active number there. Under the HOA Act 643840, the requirement is 34% of the votes. Under the new Act 6434 section 336, unless the bylaws, sorry, I was going to say it's 25% for that one. Again, these are all in the event that the bylaws don't specify. So, and finally, under the old Act 6432 380 section 3C, the requirement is a majority of the votes, not a percentage. I believe that covers it. Ken, did you want to add anything to that?
Just that most of the problems we see with documents silent about quorum are very old homeowner association documents. And so this isn't something that comes up a lot, but if you were an HOA now, it's 34%, but when WUCIOA takes effect, it will drop to 20%. And it is possible to have even lower quorums written into the documents or higher quorums written into the documents. So to some extent, you can choose what quorum you want. Next question. For associations that qualify for the small community exemption in WUCIOA, and I'll just stop and say that is section 6490-360, subsection 4. This is one which allows a community with low annual dues and relatively small number to avoid some of the burdens of the association. But the question is, what are the pros and cons of opting out or adopting the full statute? So many sections of the statute are applicable even to communities that qualify for the exemption that it's difficult to see the advantage of opting out. So the short answer is that the full statute provides more protection for individual owners, but it also creates greater administrative burdens and costs for the association, which means your dues are higher. So it's basically a cost-benefit analysis. I do want to correct one of the statements in the question. The default under the statute is that the entire chapter does not apply if you meet the criteria of under 50 units and under $1,000 a year of assessments. So it's an opt-in to the full statute rather than an opt-out of the full statute. And then I'll also note that the statute section 364 was amended in the 2025 legislative session, and it went from having a list of about 6 of the requirements of WUCIOA applying to a list of, I don't know, looks like maybe 60 or 70 of the requirements applying. And so the difference now between the statute as it applies to these small communities and the statute that applies to everybody has substantially been reduced. A lot of the statute is regarding things about developer rights, or about master associations and sub-associations. None of those would apply whether you are under the full chapter or just this exception chapter. But the developer community pushed really hard for a change this year to increase the exceptions to communities as large as 50 lots and communities with annual assessments not exceeding $1,000 instead of the previous number of $300. Anything else you want to add on that, Tima?
I don't think so, Ken.
Well, I think that's the list of pre-submitted questions. Chelsea, did we get any other questions put in the chat?
A couple. So the first one I've got is, if a board denies an ARC, can an owner resubmit it again?
Well, I would say sure. Perhaps they would modify it somewhat so that it would be more likely to be accepted. But if the goal is to try and use a default approval that's in the documents to somehow force an acceptance of something that's already been rejected, I'd say that won't work. So if you submit the same application a second time, hoping that the committee will fail to respond within 30 days, and if your documents specify a failure to respond is considered approval, I think the first rejection is going to apply to every resubmission of the document. So I'd start to wonder when you ask that question, what you're trying to accomplish and what rule you're trying to get around. So I'd need more specifics to really have a good answer. Any thoughts on that, Tima?
No, I agree. I agree with what you said. I think you're welcome to resubmit it, but again, if it's not substantially different from the first one that was rejected, I don't know that you'll have any success.
All right. If not for condo law weekly sessions, how would we know about WUCIOA? I wasn't sure if that one was rhetorical, but figure we can still point people towards resources.
Well, if you're a member of the WSCAI, we do get often at least weekly emails about updates to legislative changes. And there's other online resources, I suppose. Ken, did you want to?
Well, there is this fantasy, I think, related to legislation of all kinds, that once the legislature has adopted a new law and the governor has signed it into place and it takes effect, that everybody knows and obeys. This is true with criminal laws. It's true with, the WUCIOA is one tiny little bit of legislation that the governor signed into law for this year. And we know about it because we proactively follow it. And, one of our partners is on the Legislative Action Committee. And so we know about this one, but the assumption from the legislature is that you are all paying close attention to the laws that they have changed, and you are obeying them as if you did understand them. Just like when the city changes the speed limit on the streets, the assumption is you are all going to change what you're doing just because they've changed the sign. So is there some public notice? No. You have to proactively look for these. And it's why we still have communities who 7 years after the requirement for budgets to be ratified by their members are still not ratifying budgets, because no one is bothered to pay attention and know that the law changed. And I don't know the solution, so when the laws change about anything else, drinking or driving or, having a driver's license, if it's not significant enough to make the news, then it just changes and you might get caught up by it. Chelsea?
If the reserve funds are well below the recommended amount stated in the reserve studies, can the board be held responsible for breaching its fiduciary duty?
I would say no. And there would be sort of two qualifiers for that. One is that if they are disclosing, as required by the budget ratification process, that they are well underfunded, then there's no surprise to anybody. There couldn't be any claim for damages against the association. And then the second thing is that the statutes and most governing documents have really substantial protections for the volunteers who are serving on boards. And if they are acting in good faith, meaning they're not stealing anything, then they are protected from any personal liability. I'll offer, I get frequently this comment from owners who don't want to pay special assessments that somehow the failure of the board to collect money in reserves has injured them. The reality is that they didn't pay the money in the past. If the board had asked for them to pay the money in the past, it would still cost just as much to replace the roof or whatever the project is that they're now funding. It's just the timing has changed, not the amount of damages. Got anything else, Chelsea?
Nope, that's it.
Well, then I'm gonna suggest we all go home and work on something else for a while. Thank you for joining us today, and we'll see you next week.
Thank you. Have a great day.